Welcome to Embargoed, a podcast featuring intelligent talk about sanctions, export controls, and all things international trade for trade nerds and normal human beings alike. I am one of your hosts, Brian Fleming. I'm here with my friend, colleague, and co-host, Tim O'Toole. What's up, Tim?
What's up, Brian?
Welcome to everybody. This is episode 2 or sort of part 2 of our initial episode of Embargoed. If you haven't checked out our first episode, please do so. That is available on iTunes, YouTube, and anywhere else you get your podcast content. We today are going to pivot to talking. In the first episode, we talked about sort of major sanctions developments of the last and export controls developments the last couple months. Now we're going to talk specifically about enforcement actions, something near and dear to our hearts. And we're going to sort of start with a few things from late last year and come into 2020 to talk about a few major developments. So we're gonna, the format here is we're gonna run down sort of a few major cases in a little more detail, and then we're gonna wrap things up with a lightning round and a few final thoughts. So before we get started, anything you wanna add, Tim?
Nope. Big time in enforcement, though. It was very nice of the enforcers to help us out by giving us some material this week.
Exactly right. All right. So with that, without any further ado, let's jump right into running down item number 1. So in late December, literally the last day of December 2019, there was a decision that came down in the Exxon Mobil litigation against OFAC. And so this, I think, is a logical place as any to start because this
New Year's Eve revolution.
Yeah, it's something to read over champagne cocktails on New Year's Eve. So just to give a little bit of background on the case before we jump into what this may all mean. So some number of years ago, back 2014, Exxon signed a number of contracts with the Russian company Rosneft. Rosneft not an SDN, but its CEO, Igor Sechin, is an SDN and was an SDN at the time, and he was the signatory on those contracts. Fast forward a few months, Exxon gets a subpoena and eventually goes back and forth with OFAC, and OFAC takes the position that having Mr. Sechin, while he was an SDN, in his individual capacity, sign those contracts was a sanctions violation because it meant that Exxon was receiving services from an SDN. And so Exxon disagreed. They disputed this all the way through the agency. A penalty notice was released, and then Exxon brought the case to federal court in Texas. And the decision that came down in late December, for people who follow this stuff closely like we do, was notable because Exxon actually won. They took on OFAC and they won. And that doesn't happen very often. And so I think this is worthy of we could probably spend an hour just talking about this, but there's a lot of different aspects of this that I think we want to cover. Essentially, just to summarize for people who haven't read the opinion or who haven't followed the coverage on this more or less boiled down to the question of whether or not Exxon had fair notice of how OFAC would interpret the receipt of services, the concept or the term receipt of services, and whether or not they had fair notice to understand at the time that these contracts were signed that OFAC would view that as being dealing in the property or property interests of an SDN. Which would be a violation for a U.S. person at the time. And the court, after looking at this in a very lengthy opinion, basically came down and said, no, they did not have fair notice. And that's a violation of due process. And I'm going to throw out the penalty that was imposed, the financial penalty. So there's a lot of other things that I think we'll touch upon along the way here. There's a couple key points that for anybody who practices in front of OFAC and who interprets OFAC guidance and who looks at and tries to decipher the Rosetta Stones of OFAC FAQs on a daily basis like we do, or even less frequently. There's a lot here, but let me just start there. Let me start and throw it to you. What are your sort of initial thoughts when you saw this come down, when you saw the decision that rested on this idea that there was no fair notice for OFAC's interpretation? Sort of what are your initial thoughts on that?
So I think this decision is a big deal if it holds. And the reason that I do is that the question that was in front of Exxon, the answer wasn't clear. but it was as clear as many of the questions that we have to answer with respect to what can you and can't you do with sanctioned parties. And so here you had Exxon was dealing with a company that under the Russian sanctions it was allowed to deal with. There's no question that it was allowed to sign this contract with this company. But could they deal with the countersigner be a sanctioned party from the other company, even though he wasn't a party to the contract? He just was acting for the company to sign, and he was the SDN. Maybe yes, maybe no. Now, what would you do if you were going to look for guidance on this? Well, there was a frequently asked question that OFAC had done in the Burma sanctions program. So it wasn't Russia, but it was Burma. And it said, if there's a company that is sanctioned or not sanctioned, but the individual signing the contract is sanctioned, you can't do it. So it was directly on point, but it was a different program.
And importantly, which comes up very frequently in the opinion, OFAC loves to caveat their guidance, their FAQs, by saying our programs, we interpret these rules differently in different programs. They like to maintain maximum flexibility
and maximum what they call strategic ambiguity.
Exactly.
And it wasn't all that strategic here, because that desire to make sure that even guidance in a different program that's exactly the same set of facts doesn't apply in another program really came back to bite OFAC. And I think rightly so in some sense, because you want to maintain strategic ambiguity. Due process requires fair notice. And so you can't come back later and say that they had fair notice when your whole point was to keep things ambiguous so nobody would know what they were supposed to do.
We should add on that exact point. So first of all, this Burma FAQ is something they pointed to in the context of the lawsuit as why Exxon should have had fair notice. The court disagreed with that ultimately, in part because OFAC, of the language OFAC has in there, that caveats that says that we essentially reserve the right to interpret these rules differently across different sanctions programs. So that's one thing. The second thing is there was two new FAQs that came out right after the Exxon case came to light in front of OFAC, and it essentially readdressed this issue in a more squarely, although not naming obviously these parties, to what seems to any reasonable person to mean they understood that there was a lack of clarity. So they issued an FAQ after.
And the court said that. I mean, the court held it against them that they came out with this guidance after they imposed the penalty.
They called OFAC out for that. That's exactly right. And so that, I think, is another interesting sort of an interesting piece of this, which is, OFAC, as many who deal with OFAC, and as we deal with OFAC, in all respect to our friends at OFAC who are just trying to do the best job they can, we know they do like to have it both ways. They do like to maintain flexibility maximally whenever they can, so that they can essentially reserve their right to change their mind whenever, and have preserved that strategic ambiguity to sort of paralyze people from getting anywhere near sanctioned parties in some instances, depending on your risk tolerance. But when they want to sort of crack down on somebody, then they are very quick to say, well, no, this was clear.
This is all completely clear.
This was clear because of some guidance that was issued in a program that has nothing to do with the conduct you were looking at, that was, arguably, literally like looking for a needle in a haystack. If you were going to,
so I guess to me, the question now is kind of what's going to happen with some of these things, assuming this decision sticks. So, for example, OFAC both got called out because it has all of these caveats saying, if we provide guidance in one program on exactly the same question, you can't use it in determining what your obligations are in another program in exactly the same set of circumstances. Are they going to keep those disclaimers? Probably yes, but it sure got them in trouble in this matter, because if they hadn't had those disclaimers, I think this case would have come out differently.
Right. I mean, I think the other thing to keep in mind is this was sort of a perfect storm, right? Because as we know, companies are not inclined usually to push these matters all the way through to court, because this is years. We're talking about, this is 6 years ago,
it's
5+
a big
years
deal
ago.
that they fought.
It's a big deal that Exxon fought. And I think, many have said, well, is this going to now set a precedent where companies will feel more emboldened to push back if they feel like they're being, treated unfairly by OFAC or held to unreasonable standards? And, I think we'll see, but I do think it's worth noting that this was kind of a perfect storm, right? Because The penalty amount that was imposed here was relatively low, and so you would think it was $2 million essentially, right around.
And it was a much bigger contract.
It was a much bigger contract than that, but again, this was sort of a matter of principle, like as far as everything that was said about it and the court filings and everything else. And they said, this is just unfair and we're not going to abide this. So we're going to fight this. And, I think it sort of does show that there is a path to do that. If you have sort of the stomach and you want to, invest in the legal fees and the time to battle something like this, you can do it. I think another interesting kind of related point here which is something that we also wrestle with all the time. There was a discussion here in the opinion about the fact that Exxon did not go get guidance before they signed these contracts. And the court essentially says something, and I'm paraphrasing that, we're taking note of that, but it's not ultimately dispositive.
We'll hold it against you, but you don't lose just because of
exactly. That. And as anybody who deals with OFAC knows, trying to get guidance out of OFAC either in any kind of timely manner or in any kind of meaningful level of specificity is almost impossible. It's almost impossible.
That's one of the things that opinion almost seems kind of written in a hypothetical world where the judge doesn't know anything about practice in front of OFAC, because this notion that Exxon could have reasonably gotten meaningful guidance from OFAC in any time of in less than 3 years is just not realistic.
Yeah, if they had pursued formal guidance, that request would probably still be sitting on somebody's desk in OFAC 6 years later. And if they had tried to get informal guidance over the phone or via an in-person meeting or something like that, who knows what they would have gotten, or whether they would have been able to even get something that would have been, change their calculus here. So that's pretty significant, that because we have these discussions all the time, whether it's sort of better to, and some people are believers that, look, just put in a guidance request. We know we're never going to get an answer, but then it's sort of, we've tried, and if they can't really hold it against us if we asked and we never got an answer. We sort of have proceeded in good faith to let them know what we're doing. They had the opportunity to object essentially, or tell us that we got it wrong.
Right.
And they haven't done that. So we went forward, and how bad will it be ultimately if that's where we net out? And there are some people who believe in that in every case. Some people who we have certainly done that in certain cases. There's sort of, that's a case by case question, but more often it's exactly this scenario, which is you do your level best, whether it's internally or with your outside lawyers, to sort of look at the rules and interpret those rules and say, look, based on what we know and based on the guidance, this seems okay. So we're going to do it. And we will have a memo to the file or whatever. We'll sort of memorialize the guidance we got, but we're going to go ahead and do it because the pace of business is not such that you can sit around for 4 years and wait for an answer that may never come.
Well, and they had a number of other reasons to think, Exxon had a number of other reasons to think that the answer was yes, right? I mean, not only was the contract with Rosneft not sanctioned. I mean, there's no question about that.
Right.
But the Treasury Department officials had made a number of informal and even formal statements that the sanctions against the CEO were in his individual capacity, that they weren't trying to stop business with Russian companies. They were just trying to go after the particular individuals. And so, and that shows up in the opinion. Exxon relied on that. And so I think part of the reason they may not have sought guidance is because they thought that the Treasury's statements, their public statements, were signaling what the right answer was to it, and they didn't really want to spend 2 years getting some, answer from somebody else when Treasury had sent so many signals in the opposite direction.
Okay, so in any event, I think there's, we, again, like I said, we could talk about this for an hour. I think we'll kind of wrap up there, but just sort of a final thought. I think just to keep your eye on going forward. Obviously, we'll see if this decision holds. This is also just one federal district court in Texas. This is not, and we'll also see whether or not the OFAC changes its practice or approach at all, or if it essentially just chooses to ignore this and say, okay, well, we got beat in that one case, but we're going to continue to maintain strategic ambiguity. We're going to continue to sort of do and structure these things the way that we always have. and we'll see if anything actually changes. And the flip side of that, of course, being whether companies are going to actually change their attitude, whether we could see more court challenges, whether we could see just different behaviors in light of this, which is again the very rare thing that does a real deep dive into an OFAC penalty and picks it apart and then ultimately overturns it.
Yeah, I mean, I think it'll have a big effect on OFAC because at the end of the day, the answer to a lot of these questions is not very clear. And so they could go either way. And so often, if you didn't have fair notice, if Exxon didn't have fair notice here, then I think a lot of the clients that we see and a lot of the people who are in front of OFAC don't have clear notice as to what the right answer to the question is unless there is OFAC guidance directly on point.
And I think another interesting point is that in the event that somebody is seeking guidance in front of OFAC or is arguing why perhaps a penalty isn't appropriate or some conduct does not amount to a violation, now will OFAC be more sensitive to an argument that says, look, we didn't have fair notice of this. Here was the reasonable interpretation that we applied based on this. And if you say that it's the opposite of this, then no fair notice. And you could signal to OFAC a bit that you might be willing to sort of go to the mattresses on something like this. So it'll be interesting to see if that changes anything at all as well.
Yeah, and this is all not to pick on the people at OFAC. I mean, they have a hard job. They're trying their best to do it. They're understaffed.
Yeah. I mean, we get it. We get all that.
We get it. Yeah. And you know what? I mean, it's really hard to make a one size fits all sanctions policy that everybody can understand from the get go. So
totally
it's not picking on OFAC, but this is a big deal.
Yes. All right. So with that, we'll wrap up Exxon and we'll move on to item number 2.
All right. So let's talk about Airbus. So, this was some of the new material that enforcers gave us within the last week, and specifically DOJ. Airbus, as I think most folks know, is a European company that makes airplanes. It makes commercial airplanes, and it makes military airplanes. Now, the commercial airplanes was a big part of the settlement, was a big part of the headlines. Because according to the Justice Department documents, Airbus was paying bribes in China to get commercial airplane contracts. We're not going to talk about that. That's a FCPA issue, an issue that lots of people would be more qualified than us to talk about. So we're going to set that issue to one side. What we're going to talk about is kind of the second part of the decision, or the second part of the deferred prosecution agreement, because Airbus entered into a deferred prosecution agreement with the Department of Justice, criminal charges on the FCPA, but also criminal charges under the ITAR, the International Trafficking in Arms Regulations that are administered by the State Department, the Directorate of Defense Controls, what we'll call DDTC, and the State Department administers the ITAR. Those apply to sales of military goods. And as I said, Airbus makes military airplanes, but they're a European company. Why does the ITAR apply to Airbus? That's the first question. Well, the ITAR applies really broadly. And so the U.S. enforcers take the position that if there is any part of any military plane, or even any military part of a plane, so it might be a normal airplane, but a commercial airplane, but you add something to it that makes it go really fast or makes it be able to maneuver like a military plane. If that part is a U.S. part, then the U.S. enforcers take the position that the ITAR, U.S. law, applies to transfers, to exports, to sales of that plane. And so Airbus airplanes were subject to the ITAR. So it was, even though it was a European airplane, military airplane manufacturer, it was subject to the ITAR. Now, why does that matter? Well, the ITAR, when you sell an airplane that's subject to the ITAR, you've got to get permission from the State Department in order to do it. And so you've got to get a license. And so Airbus was selling airplanes in Ghana, in Indonesia, in Austria, and other places that they needed State Department approval to sell the planes. Okay, well, they got the State Department approval. So what's the big deal there? Well, to get State Department approval, you've got to tell the State Department if you paid any commissions, if you paid any fees, if you paid any sort of political contribution in connection with the project. And Airbus was apparently hiring consultants who were working with the governments in those countries to help them get those contracts. When it went to the State Department to apply for licenses, it didn't disclose that. And so they didn't comply with what's called Part 130 of the ITAR. Okay, so,
So what, Tim?
So
Tell me
what?
Why does that matter?
Well, the reason that, one, it matters because the ITAR does require it. And if you don't do it, then you can get in trouble. But normally, Part 130 is a relatively obscure part of the ITAR. Nobody knows that much about it. And so normally it would just be a civil problem. But BAE, another defense manufacturer overseas in the UK that was subject to the ITAR, got in trouble in 2011 for exactly the same thing. So they had basically gotten these defense contracts overseas. They had paid consultants to help them get them. These consultants were sometimes like the brother of an elected official, and they'd pay them, tens of millions of euros to help them get the contract. They got the contract, and then when they got the license from the State Department, they didn't say, we paid commissions to the brother of the guy who made the decision here. So when BAE got in trouble in 2011, it was big news. And Airbus apparently wrote memos and had meetings to talk about what they were going to do about Part 130 of the ITAR. And ultimately, it was decided that they weren't going to do anything about Part 130 of the ITAR. And they decided not to disclose to the State Department officials who all these consultants were. And so not only did they violate Part 130, and again, this is according to the plea documents, so we're going to assume those are the real facts. Not only did they violate it, they did so in a way that was willful. And so essentially what you have now is you have Airbus, a foreign company, pleading guilty to violating Part 130 of the ITAR. They also did some things with brokers who would sell their goods that
were unregistered.
You're supposed to register them with the State Department. They didn't register. I think if that had been the only violation, it wouldn't have been a criminal case. But
in typical fashion, what they've done in this document, which is the deferred prosecution agreement has a statement of facts, and the actual charging document, the information sort of recites the key facts as well. In typical fashion, they go through sort of a litany of facts that are maybe a little superfluous, let's say, and they go through this idea of the unregistered brokers and sending goods to countries that they shouldn't have been sending them to, that were embargoed or that were subject to 126.1 under the ITAR. And at the end of the day, it comes down to exactly what Tim just said. The charge is actually for a violation of Part 130, which is not reporting the payments and not keeping accurate records of those payments.
Right. They basically were paying, making payments to people who were helping them get contracts in ways that, at the very least, looked very shady and looked corrupt. And instead of reporting those as they were required to do, they just didn't report them, and then really didn't keep records of them.
Right. And I think this is interesting for, at least to us, this is interesting for a couple of different reasons. So as Tim said, this is not an area where we see a lot of action under the ITAR, right? At least not on the criminal side.
Right.
We certainly don't. And so this is a bit of a unicorn of a case. The BAE case that he mentioned was a few years ago. Those are two of the most notable, if not the two most notable in this area. And the fact that this case sort of reflected upon that earlier case, and there was and this is
right. It's turn it into a criminal case
in terms of the proof and the evidence of the knowledge and the willfulness and all the rest of it. That was, it seems essential from the way that it was written up in the documents that were filed by DOJ. So that's one thing. And the other thing is, this is kind of an interesting intersection of and we should say, by the way, this was a massive resolution with DOJ. However, the lion's share of the penalties and are being paid to the UK and the French authorities. Airbus is a French company, and so those are billions of dollars in fines that are being paid to those authorities. I think it's somewhere in the neighborhood of $500 million on the US bribery, and then it's less than 100 million on the ITAR violations between forfeiture and some other things. And so, this is actually the smallest piece of those three jurisdictions working together, but this is a massive sort of undertaking. And like Tim said, this is the piece that's gotten certainly the least attention to date, because the flashy part is sort of elsewhere.
So I think it'll get a lot of attention in Europe, though, because
I think that's right.
I think that, again, like the BAE,
yeah.
Once you have this, every time you have an FCPA investigation, if you make military products, you've got to be worried about the ITAR.
Tim is getting on a plane on Sunday to go to Europe to talk about this next week. So, so if you happen to be with Tim next week, then please ask about this.
Let's talk about Airbus.
So I have two points that I want to cover. Two sort of interesting points that jumped out at me. First one is on the first episode of the podcast. We talked about the new National Security Division voluntary self-disclosure policy. This resolution makes very clear in the press release and in the documents that Airbus got credit for that. They came in under the auspices of that program, that voluntary disclosure program.
First one.
It seems
we know.
This is if it's not. This is the first one, I believe, where there's a public resolution that acknowledges that there was a party that came on under the program. So, what do you make of that? Because that's sort of a big deal. And this is and then what learnings are there from that in terms of what type of case this is, and where, again, sort of in the big picture, especially under the new policy that just got rolled out in December on the VSD guidance. What does this mean going forward?
So this is the perfect case for the voluntary disclosure policy, because what you already had a criminal case. So it's not like
on the corruption side.
Yeah. So Airbus was in the middle of a corruption investigation, and they came upon export controls violations. And so they're already in front of the Department of Justice. They've never thought initially that this was a civil case, and they don't want to make arguments to keep this a civil case. I think that if this conduct had come up in a vacuum, that they probably wouldn't have been as willing to concede willfulness here, because most of the ITAR stuff that was talked about, maybe there was a stronger case for that and they just didn't feel like putting it into the plea documents, but it didn't look anything close to willful to me. Now, this part, because of the prior history with BAE, certainly was made to look willful, but my guess is that in a different context, Airbus might have put on a more vigorous defense. But since they're already dealing with a much bigger criminal investigation on the other side.
It's almost ancillary to the corruption
Exactly.
issues, right? So
you just walk into another department of DOJ and say, hey, we've been acting diligently. We've gone back and investigated ourselves. We've found out some other stuff. Yeah. Give us credit for this because we're gonna fess up, and we're not gonna fight willfulness in a way that, in a different case they might have.
Right. So related to that, the other point I want to bring up before we wrap up and move on is in the nature of the resolution. So this is as Tim said, this is a deferred prosecution agreement, and it covers, again, primarily the corruption side of things, but it also covers the export control violations that we're talking about. There is no monitor. There was no monitor that's been put in place, not by DOJ, right? No monitor. What they have instead is this mechanism where there's it's essentially annual self-reporting by the company, where they have to bring in, on an annual basis, they have to talk about, I think the first go round, they have to talk about how they're meeting their compliance commitments, what they're doing to remediate, beefing up internal controls and processes. And then thereafter, they have to, for 2 more years, they have to also annually report back to DOJ and to all the other government agencies that were involved here on the U.S. side. So what do we make of that? Because that's kind of unusual. I don't have a recollection of where that type of reporting requirement with no monitor is just put squarely on the company, and it's just we're going to rely on you to come to us and tell us what's going on. And obviously, I'm sure that there could be or will be some back and forth after that to kick the tires on what they're hearing. But again, no monitor, self-reporting. What do we make of that?
So a couple of thoughts here. I mean, I think one of the things that's interesting about Airbus is it's part of a bigger trend in all of the white collar area for joint prosecutions between the PNF in France, and you had the SFO in the UK, and you had DOJ here, and they all worked together on this issue because they crossed so many international borders and had so many countries that had roots in different places. And so I think it's likely that was difficult to agree on if there was going to be a monitor, where was the monitor going to come from, and who was going to be the one that the monitor reported to. And so they did away with the monitor altogether. I do think that might be part of a trend. We talked a little bit in the first podcast about the ZTE resolution, and the monitor there has been a disaster by all accounts. And so,
monitors,
right? The first one was so bad that they appointed a second, and that I'm just talking about what's reported. I don't have inside information on that, but the reports are that the first one was so bad that they had to appoint a second monitor, and obviously a company that's paying to monitor itself twice is not going to be particularly happy with that. And so I do think that it's not a shock to me that we're moving away from monitors in this area. But it's also, even if there were going to be one, who would pick the monitor would be a tough decision.
Right. I think the multi-jurisdictional aspect of this and the fact that the U.S. had the smallest piece, as I said, might have played into that. Also, again, under the new, at least the new NSD voluntary disclosure policy is if you're going to come in, cooperate, remediate, and sort of follow through on all the steps that are required, then no monitor. That's pretty clear from the new policy. So I think you're right. I think it's a bit of a trend. Again, we're not trying to really opine on the general trends in monitorships that we've seen over the years in the FCPA. That's really outside of our area of expertise. But although we have plenty of colleagues we can rely on for that. But yeah, I think it is notable, this sort of annual self-reporting, just because it is something a little different. So with that, let's wrap up Airbus and move on to number 3. So the first 2 items we covered are kind of big, flashy enforcement actions, getting a lot of headlines. The next 3 that we're going to run through here, probably a little more quickly, these are all OFAC settlements that have come either in late 19 or early this year. And, unless you're deep in the OFAC world, these are not things you've probably even, or you work at one of these companies. These are probably not things you're.
$12,000.
The first one is $12,000, but we're going to talk about it anyway because there's a couple of interesting things we want to hit on. So to go to number 3, this is Park Strategies, which is a lobbying firm in New York, and they had an OFAC settlement that just came down very recently. And again, to Tim's point, it was all of $12,000. Is the ultimate penalty that was paid. But the circumstances here are noteworthy, and this was just a couple weeks ago. This is late January. So essentially what happened is a lobbying firm gets hired by an SDN to undertake some lobbying work on their behalf. And again, we have a very limited set of facts from the penalty notice that's public on OFAC's website, but what the focus here really is whether or not, or not even whether or not, but the idea that somebody who is acting on behalf of an SDN is covered by the general license that would be available under that particular sanctions program. As people who work in this space know, basically every sanctions program that OFAC has, there's some kind of general license that allows for legal services. And the specific types of legal services that you can provide are set forth in that general license. And again, I'm kind of paraphrasing and summarizing, but it's usually, you can explain and give counsel and guidance on the scope of U.S. law. You can, represent somebody in a lawsuit in the U.S. There's a couple of other things that are typically articulated in each general license, but it's 3 or 4 things, and they're pretty concrete. And if you are going to proceed under that general license, there are other rules that apply in terms of how you get paid and filing your engagement letter with OFAC, and et cetera, et cetera. So I think the interesting thing here is they take great pains to say this wasn't a law firm. This is a lobbying firm, not a law firm, not providing legal services, right? Number 1. Number 2, I suspect, and I've seen this reported outside of the penalty notice, that this firm was engaged in some lobbying activities that were intended to, I guess, boost the prospects of this SDN to get off the SDN list. Right. And so it is adjacent to, at least, activity that would be covered by the legal services.
You could represent we do it.
We represent parties that are on the SDN list in front of OFAC in efforts to get them delisted.
And that's clearly covered by almost all the general licenses.
That's exactly right. And so I think the interesting thing here is this idea that perhaps, and again, I'm speculating, but if you were engaged in activity that is kind of adjacent to or supporting that type of activity, which is clearly authorized, there are limits, and you cannot, they are hard and fast. And if you are outside of those limits, you would have to go to OFAC and get a specific license, or else it will not be authorized, and you will potentially be violating the sanctions.
Yeah, I mean, I think this was kind of designed to flag for everyone what you can't do, at least that looks somewhat like the sort of things that you can do as a lawyer representing people in front of OFAC.
Right. And so I think that's really the big point that we want to make. And again, this is something that jumps out at us because we spend a lot of time staring at these general licenses and making sure that everything we're doing is compliant. And we talk to other lawyers about this all the time. But with respect to this one, on the lobbying front, and again, on behalf of a party that is seen to have been at the time pursuing potentially relief from its listing, if you're outside the scope of that, then you would need a license.
Be careful.
Yeah, be careful.
Not legal advice.
Yeah, we're not giving you legal advice, but be careful. Yeah, that reminds me. I think I forgot to give the disclaimer at the outset. We're not giving anybody legal advice, so you have to call us separately for that. So let's put that one aside now, and then move on to item number 4, which is another recent OFAC settlement.
So this one is from December. It involves Allianz Insurance, and it's another kind of small matter, but I think it's worth talking about because OFAC has imposed penalties for things like this a lot recently. Allianz is an insurance company. There's a U.S. insurance company. They had a branch in Canada. In Canada, Canada doesn't have any sanctions against Cuba. So if you live in Canada and you're a Canadian citizen, you can go to Cuba anytime you want, and you don't have to make up a reason to go or to provide one of the 12 reasons that you're allowed to go as a U.S. person, none of which can include tourism. So U.S. persons can go to Cuba as long as they're not going there to be tourists. Canadian persons in Canada, flying on Canadian Airlines, can go to Cuba for any reason they want. Why does this matter? Well, Allianz Canada, which is a branch of the U.S. insurance, provided travel insurance for Canadians to go to Cuba. It actually provided just travel insurance, period, and wasn't really asking people where they went. But one of the places that they could go was Cuba, and they went to Cuba a number of times on Allianz Canada, a branch of Allianz U.S.'s travel insurance. And OFAC found out about that. OFAC imposed a penalty because under the U.S. sanctions against Cuba, they apply not only to U.S. companies, but U.S.-owned or controlled companies. Now, because Allianz Canada was a branch, it probably was technically a U.S. company anyway. But at the very least, it was a U.S.-owned or controlled company, which meant that it couldn't provide travel insurance to Canadians who could lawfully travel to Cuba for the travel to Cuba because it was providing a service to Cuba within the meaning of the Cuba regulations. So why does this matter? Well, it just is another example of enforcement actions against Cuba. Cuba was not an enforcement priority prior to 2017.
And in fact, it looked like it was heading toward potentially going away altogether as a sanctions program.
Well, and in fact, it's actually permissible to provide travel insurance to Cuba now, even. But in 2015, it wasn't permissible. Right. And so all of this conduct was pre the loosening that took place in the Obama administration. But Cuba enforcement actions and Cuba travel has become a big enforcement priority for the OFAC Trump administration.
Right, and the companion case that was announced at the exact same time, which involved Chubb and a subsidiary of Chubb, as well. Similar facts. This was European travel and insurance of European travel. Spain, I believe, was sort of the hub there, going to Cuba, and there was no sanctions and exclusion clause in the policies. And there was it seems from the penalty notice that there was perhaps a misunderstanding of what rules applied and whether or not that particular those policies and that those insureds would essentially be covered by this. And again, I think in the case Tim talked about, the Allianz case, where there was a general policy, a global policy, but no carve out for Cuba. Similar on the Chubb side, there was no sanctions exclusion clause. That was sort of the teachable moment that comes out very clearly from the penalty notice. So it's just one of these, for and we talk about these things all the time for trade compliance folks and other people who are trying to write policies and sort of do the right thing. This is one. This continues to be a bit of a tricky one with respect to Cuba, where there has to be some special care and attention paid when you have generally applicable policies that might work around the world, But with respect to Cuba, if there's a U.S. parent, there's any U.S. connection, there needs to be probably an additional layer of care given and something else that might need to be done.
And it's just another example. These are travel insurance, and there's actually some other travel insurance enforcement actions from last year. But beyond that, companies that have branches or subsidiaries or overseas entities that are working in a country that doesn't have any sanctions against Cuba and where nobody's thinking about the Cuba sanctions, when you have a U.S. connection like that, the Cuba sanctions apply to you, and companies and individuals are getting in trouble a lot more now because of interaction with Cuba, usually involving travel, that it wouldn't be their first thought to think, oh, that's probably illegal, but because of the U.S. touch, it is.
Right. Okay, so with that, let's move on to our final major topic of the day, which is one last OFAC enforcement action, which just came out very recently in January, and this one is actually this is the Eagle Shipping settlement, and this relates to the Burma sanctions program. So we mentioned Burma earlier because of that FAQ in the Exxon case. I can guarantee you we're the only podcast in America to mention the Burma sanctions program twice.
We're going to talk about sea sand though as well, which is pretty awesome.
So I feel good about that. And the reason that I am confident we're the only ones is because the Burma sanctions program doesn't even exist anymore. In fact, it was mothballed in late 2016. And the SDN that was at issue in this case also came off the list in 2016. However, I think this action has a few interesting notes that are worth talking about, in part because when I read this, it sort of reads as a almost an instruction manual to how to recognize red flags. And there were a number of red flags that came out here, and a number of steps and decisions that were made that are the type that absolutely infuriate U.S. enforcers. And so it's no wonder that even though we're talking about an agreement that was we're back in 2011, and we're talking about moving, like Tim said, literally sand from Burma to Singapore. Why would anybody care about that? That's a good question. Well, if you apply to OFAC for a license and they tell you can't do something and then you decide to do it anyway, that's a bad fact. And that's what we have here. So I'll toss it to you to hit on a couple of highlights from Eagle Shipping.
So this is just like an awesome set of facts. So I don't know if you watch Below Deck, but there's like this like really kind of gruff, like grumpy captain, and I think he actually might have been on this boat because so basically what you have is this Burmese company that was on the SDN list, and we're going to call it Burma because OFAC does, but not only have the Burma sanctions not existed for years, Burma hasn't even existed for years. But so you have this company, they want to ship this sea sand. They come with these documents that show that the company's name, the company is on the SDN list, and so they get sent back. And then they come with some new documents that show some other company at exactly the same address, but it's not called the SDN company.
Red flag.
Right. Red flag. Okay. But the decision makers at the shipping company say, do it. And you've got this captain who's like, hell no. He's like, I'm not doing this. Look, it's the same company. And so they ultimately fight about it. And then the company decides to go ask OFAC for permission. But because there's so much pressure put on by the Burmese government to send this sea sand, the ship sails while they're waiting for OFAC's permission. And then OFAC says, no, you can't do it, but the sand's already gone. They go back and ask for permission again to send more sand. OFAC says no again. You've got this captain fighting with the company about whether they're going to take the sea sand the whole way. And ultimately, when OFAC finds out about it, it's not pleased because, like you said, when OFAC says no, you're supposed to listen to them. And when you don't, you can get into a lot of trouble, which is what they did here. But I just love the fact that you got this captain that is like, I'm not taking this stuff. and too bad. He certainly wasn't the one that got in trouble, but
Right.
but it was kind of a weird standoff where the captain is saying no because he's reading the documents.
Yeah, and so again, I think the main takeaway here, the idea that there would be a penalty imposed on conduct that's almost a decade old under a program that doesn't even exist anymore, you have to have a pretty unique set of circumstances to make that happen. I think that's exactly what you have here, and that's, as Tim said, these are some really interesting facts that you don't see very often in some of these and in some of these cases. And so it's worth a quick read. And for anybody in the compliance world who wants to use this as a training example of how you spot these things and what to do, what not to do, I think it's a pretty good one. We don't see too many that rise to this level. Okay, and with that, let's we're going to go ahead and wrap up. That's kind of the main portion, our rundown of the main issues here. We're heading down the home stretch. We're going to move to the lightning round. We're going to hit 3 issues in the lightning round, and then we're gonna wrap things up. So Tim, why don't you go ahead and get us started on lightning round? We're going to try to be more lightning than we were in episode 1, which
we'll see.
Admittedly, we were not that lightning.
And we're going to be quick.
We're going to try. We're going to try really hard to do this actually fast. Let's go.
All right, Virgil Griffith. So otherwise known in the media as the crypto bro. So Virgil is apparently some sort of expert in cryptocurrency, decides that he wants to go to some sort of boondoggle conference in North Korea to talk about cryptocurrency. Ask the State Department, because right now there are restrictions on even the ability to travel to North Korea, which is somewhat unusual for sanctions. It's really mostly Cuba is where the travel restrictions are, but there are travel restrictions on North Korea. He asks the State Department for permission. The State Department says no. Virgil goes to North Korea. This is the allegation. He's been charged. So, who knows if they're true, but the allegations and what's been reported in the media is that he goes to North Korea, attends the conference. There's more allegations that while he's there, he starts to try and send money transfers from North Korea, which is also a big problem under U.S. sanctions if that's what he was doing. And then returns to the United States, and guess what? He's arrested when he comes back to the United States because he asked the State Department to go, and they said no, and he went anyway.
Yeah, I think the big and while I should add that in the charging documents, it's alleged that while he was in North Korea, he's essentially teaching the North Korean audience how to use blockchain technology to evade sanctions.
Right.
So again, that's about as big a middle finger to the U.S. government as you can possibly give at this point. And so my quick takeaways from this, and we should add, he's a U.S. citizen who was living abroad, but is a U.S. citizen. So that's why this all matters ultimately. So a couple things. Number one, again, we were just talking about, if you ask and they say no and you go anyway, then you do so at your own peril.
That's bad. That's our legal analysis, not legal advice.
Not legal advice.
Legal analysis.
Yeah, that's nuanced legal analysis right there. If you ask the government, they tell you no, and you do it anyway, then you're doing so at your own peril. The second thing, and the last thing I'll add, crypto. We have not seen crypto is if it's not full-fledged at this point, it's at least an emerging sanctions evasion tool. And we know that, and OFAC has started to pay more attention to this. They've issued guidance on Venezuela has issued or tried to issue a cryptocurrency, and they said, yeah, that's off limits for U.S. persons. This is something that we've heard rumblings about in other parts of the world. Obviously, the North Koreans are interested in this. Something to keep an eye on. I think there's going to be a lot more blockchain and crypto-related evasion cases over the next few years. That's me looking at a crystal ball.
Yeah, no, I totally agree. In his defense, we will say that his lawyers are quoted in the media saying they're not talking, but they'll tell it all to the jury at trial, and the jury will see that he is innocent of all charges. So that could happen. We're not ruling that out, but at least from the media reports, this looks bad. Yeah,
very, very key to and the press release and the charging documents. So anyway, all right, that's number one. Let's go to number two quickly. So just recently, actually, just on Wednesday, it was reported that a Spanish executive of a hotel chain, Melia Hotels International, had received notice from the United States State Department that he was not going to be able to get a visa or was going to be banned from traveling to the U.S. And the reason for the ban was because his company has been linked to the expropriation of property in Cuba and trafficking in property confiscated by the Cuban government. So this is what just went into effect in Cuba under the Cuba sanctions. This provision had been waived for decades and just went back into effect last year. And this is one of the first instances where we've seen somebody kind of publicly acknowledging that this has happened. And there was a claim in the article that the company, or that they were aware that 50 other individuals or 50 other companies have been also so notified. So it's going to be fascinating to see who else has been touched by this and how the reaction is going to be, whether this gets challenged. We expect that there could very well be court challenges to these types of restrictions, and so what are your quick thoughts on that?
Yeah, quick thoughts. So this is Helms-Burton, a law passed kind of in the run-up to the 1996 presidential election, where Helms and Burton in Congress passed the law that President Clinton signed that was really kind of directed to tighten the sanctions against Cuba. It's what made it was what Obama couldn't undo when he was kind of loosening the sanctions against Cuba. It was mostly dormant. Now, this travel provision was invoked once back in the 90s against a Canadian executive. I actually had to do some research for a case that I was working on. Hadn't been enforced or invoked in the last 15 years after that. So this is the first time in quite a while that they have imposed it. But basically, anybody around the world, and certainly in Western Europe or in Canada, doing business in Cuba is probably subject to these sorts of travel bans. And so essentially they ban the U.S. executive, or ban the foreign executives from coming to the U.S. It's kind of a big deal. And the fact that it is being revived is kind of one of many ominous signs coming out of the Helms-Burton Act.
Not to mention whatever the knock-on effects of this are going to be now that this has been publicly acknowledged, and with respect to banks and other repercussions, even if that's not strictly part of this, as we know, anytime somebody is subject to any type of U.S. restriction or sanction like this, there's usually a big sort of bubble around that where there's some compliance concerns that are going to have to be navigated.
That's the banks basically say this person is too risky, and they stop letting them use their checking account.
Okay, so on that, let's move on to the last topic, which is coming back to a favorite from episode 1, Huawei.
So very quickly, so part of the enforcement action against Huawei was that Huawei and some of its officers were indicted in I think it's the Southern District of New York. It might be the Eastern District of New York, but it's in New York City, and they've been indicted for sanctions evasion related to sending items to Iran that they got from the U.S., but also for money laundering. And the reason that that's important, wire and bank fraud. So essentially, they weren't telling the banks that they were getting money from what they were doing with the U.S. origin goods. That's the allegation. And so after the indictment came down, but before it became public, the CFO of Huawei, a woman named Meng Wanzhou,
who's the daughter of the founder,
and the CEO, she was changing planes in Vancouver when she was picked up by Canadian authorities on the U.S. indictment that had not been public to that point. It was a sealed indictment, but it was unsealed at the same time that she was arrested by the Canadians changing planes in Vancouver.
This is in late 2018. This is a while ago.
So it's about 2 years ago. And the U.S. has been trying to extradite her. Now, the extradition proceedings are a little bit complicated because the underlying charges in Huawei relate to U.S. sanctions against Iran. Well, the main principle of extradition is that there's got to be duality. You can't extradite somebody to your country to face charges for something that's not a crime in their country. And so in Canada, Iran sanctions are not in play. And so violating the Iran sanctions is not really a crime in Canada. So if that was the entirety of the indictment, then there wouldn't be duality and she couldn't be extradited to the U.S. But because of the money laundering charges and the bank fraud charges, which are crimes in other jurisdictions, that's really the linchpin of the argument by the U.S. that there is duality, and so essentially she can be extradited to the U.S. because there's what she did was not only a crime in the U.S., it would be a crime in Canada.
Right, and so her trial in Canada on this legal question of whether or not she can be extradited is ongoing right now. And it's going to be fascinating to watch. My quick take as a former prosecutor, having dealt with these issues, is, fraud is fraud. And anytime we had a charge that was fraud-based in just about any jurisdiction, we felt pretty good about the fact that we could get dual criminality. And that's ultimately what this boils down to. I will say, though, given how politically charged this is and how there, I think a lot of people know, there are a couple of Canadian citizens that have been held by the Chinese, largely seen as retaliation for this. And so this is very fraught. It's politically charged. Whether the Canadians will potentially yield to the Chinese demands to let her go and not have her extradited, that is an open question. I mean, it seems that they are holding the line and they are going through the process, but we will have to see. So this is a very big deal, because if she is allowed to go back to China and doesn't come back to the U.S., it's going to really harm U.S.-Canada relations, and it's going to be, it's going to be sort of another chip on the scale of the U.S.-China tensions as well. So it'll be fascinating to see.
Extradition between Canada and the U.S. is pretty common, as you know, and anybody might imagine, because people can go across the border pretty easily. And so, extradition is usually just a formality when you're talking Canada and the U.S. And if the U.S. isn't able to extradite people from Canada for fraud,
right.
And the fraud charges are pretty clear in terms of the charges. Who knows if they're true? But the indictment, there's been an indictment. It alleges fraud. It alleges all the elements of fraud, and it's Canada. It's not like they're trying to extradite her from a country that might not have that long extradition history.
Yeah, absolutely. Okay, so with that, we're going to wrap up. We're definitely going to have to get better at going fast, because
that was fast.
That was not that fast. We're long-winded no matter what, unfortunately. But with that, any final thoughts here as we wrap up episode 2?
No, I hope the enforcers, go a little bit easy so we don't have so much to talk about next time.
Yeah, exactly. Okay, so with that, we're going to say goodbye to everybody. Please stay tuned for episode 3, which will be coming your way in a few weeks. And thanks, everybody, for listening. And until next time, everybody, please stay sanctions-free. See ya.
Take care.